subjugation to the law of nature, the law of God, and the common law, all being areas of influence that the Crown had previously sought to assert dominance over the Commons. The Commons could punish for contempt as part of their unqualified jurisdiction to regulate their own procedure without reference to the ordinary courts, and could also exercise a penal jurisdiction all of its own. The two local events that I referred to clearly represent, in my view, parliamentary overreach. In the case of Udicot, the Speaker's ruling that Udicot, a limited liability state corporation, could not exercise the right of robust reply to a member who had, under the cloak of parliamentary privilege, and whatever its many misdeeds, for there were many on the part of Udicot, had quite clearly defamed the company. In the case of the suspension of the leader of the opposition, the Parliament, dispensing with the ordinary procedure to remedy a breach of the privilege of free speech, a reference to the Committee of Privileges of the House, arrogated to itself the power to charge, to hear evidence, and to rule that a breach of privilege had in fact occurred in circumstances that would warrant the immediate suspension of the leader of the opposition. I think, as I have said, that both of these actions were not simply plainly wrong, but were also unlawful. And I say so for these reasons. Mays defines parliamentary privilege as, and I quote, the sum of the peculiar rights enjoyed by each House collectively as a constituent of the High Court of Parliament, and by members of each House individually, without which they could not discharge their functions. The purpose of the privilege was articulated as long ago as 1675, when the Commons asserted that privilege existed so that members might freely attend the public affairs of the House without disturbance or interruption. It is difficult to comprehend how the exercise by Udicot of its right of reply, as robust as it